Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgments pronounced now in the area of consumer law, criminal procedure and labor law. To know more about them, please watch the video fully. In the important judgment titled Maniben Mahanbhai Bharia versus District Development Officer Dahod and others, pronounced on 25th April 2022, the Supreme Court has held that the Anganwadi workers and helpers are entitled to the payment of gratuity under the Payment of Gratuity Act 1972. The facts of the case would be that the appellants, who were Anganwadi workers, filed their applications before the prescribed authority when gratuity was not paid to them. The controlling authority under the Payment of Gratuity Act held that they were entitled to gratuity. This finding was affirmed by a single bench of the Gujarat High Court. However, the division bench set aside the single bench verdict. Being aggrieved, the present appeals have been filed with an issue posed for consideration, and that is whether Anganwadi workers and helpers appointed to work in Anganwadi centers set up under the Integrated Child Development Scheme are entitled to gratuity under the Payment of Gratuity Act. The Supreme Court has held that the Anganwadi centers are performing the statutory duty of the implementing provisions of sections 4, 5 and 6 of the National Food Security Act 2013 to ensure nutritional support for pregnant women, lactating mothers and children. As per a resolution issued by the Gujarat government, one of the important functions of Anganwadi centers is to conduct primary education activities for the children of the age group of 3 to 6 years by following the preschool timetable and by using the preschool kit. For giving effect to Section 11 of the RTE Act, a provision has been made by the state to conduct primary schools for children above the age of 3 years in the Anganwadi center. In view of the provisions of the 2013 Act and Section 11 of the RTE Act, Anganwadi centers also perform statutory duties. Therefore, even Anganwadi workers and helpers perform statutory duties under the said enactments. The government resolution, which prescribes duties of Anganwadi workers and helpers, does not lay down that their job is a part-time job. Considering the nature of duties specified thereunder, it is a full-time employment. Anganwadi centers are establishments within the meaning of Section 3B of the Payment of Gratuity Act. Section 3 mentions the entities to which the Payment of Gratuity Act applies. Taking a cue from the wide interpretation given to Class B of Section 3 in the case of State of Punjab versus Labour Court, reported in 1981 SSC 4, this court said that establishments contemplated by Class B can be establishments within the meaning of any law for the time being in force in a state in relation to establishments. Since Anganwadi centers are working like an arm of the government, the court held that they are establishment within the meaning of Section 2E of the Contract Labour Act. It means Anganwadi centers comes within the phrase establishment within the meaning of any law for the time being in force under Section 3B of the Gratuity Act. Therefore, the Payment of Gratuity Act will apply to Anganwadi centers and in turn to Anganwadi workers and helpers. Thus, the single judge was right in holding that the Payment of Gratuity Act was applicable to Anganwadi workers and helpers. The controlling authority has granted simple interest at the rate of 10% on the overdue gratuity amounts. All eligible Anganwadi workers and helpers shall be entitled to the benefit of interest. Coming to the next important judgment titled Ramchandra versus State of Chhattisgarh and another, pronounced on 22nd April 2022. In this judgment, the Supreme Court has held that a presiding officer of the sentencing court, while giving opinion on a remission application, should give adequate reasons. Inadequate reasons, in the opinion of the presiding officer of the sentencing court, would not satisfy the requirements of Section 432(2) of the CRPC. The facts of the case would be that the petitioner, who is undergoing a sentence of imprisonment for life, submitted an application for premature release to the respondent under Rule 358 of the Chhattisgarh Prisons Rule 1960. 1968. The jail superintendent of Central Jail sought the opinion of the special judge on whether the petitioner can be released on remission. The special judge gave his opinion that in view of all the facts and circumstances of the case, it would not be appropriate to allow remission of the remaining sentence of the petitioner. The law department of the government therefore held that since the presiding judge of the sentencing court has not given a positive opinion with regard to the release of the petitioner, he cannot be released. Being aggrieved, the petitioner has approached the Supreme Court by filing a writ petition. The Supreme Court has held that the purpose of the procedural safeguard under Section 432(2) of the CRPC would stand defeated if the opinion of the presiding judge becomes just another factor that may be taken into consideration by the government while deciding the application for remission. It is possible then that the procedure under Section 432(2) would become a mere formality. However, this is not to say that the appropriate government should mechanically follow the opinion of the presiding judge. If the opinion of the presiding judge does not comply with the requirements of Section 432(2), or if the judge does not consider the relevant factors for grant of remission that have been laid down in Lakshman Naskar versus Union of India, reported in 2002 SCC 539, the government may request the presiding judge to consider the matter afresh. In the present case, there is nothing to indicate that the presiding judge took into account the factors which have been laid down in Lakshman Naskar versus Union of India case. These factors include assessing whether the offense affects the society at large, the probability of the crime being repeated, the potential of the convict to commit crimes in future, if any fruitful purpose is being served by keeping the convict in prison, and the socio-economic condition of the convict's family. In Lakshman Naskar versus State of West Bengal, reported in 2007 SCC 626, and State of Haryana versus Jagdish, reported in 2010 for SCC 216, this court has reiterated that these factors will be considered while deciding the application of a convict for premature release. Further, an opinion accompanied by inadequate reasoning would not satisfy the requirements of Section 432(2) of the CRPC, and it will not serve the purpose for which the exercise under Section 432(2) is to be undertaken, which is to enable the executive to make an informed decision taking into consideration all the relevant factors. Thus, the petitioner's application for remission should be reconsidered. This court directs the special judge to provide an opinion on the application afresh, accompanied by adequate reasoning that takes into consideration all relevant factors that govern the grant of remission as laid down in Lakshman Naskar versus Union of India case. The special judge must provide his opinion within a meaning of the date of the receipt of this order. This court further directs the state to take a final decision on the petitioner's application for remission afresh within a month of receiving the opinion of the special judge. Now we are going to deal with the important judgment titled Dr. Mrs. Chanda Rania Kauri and others versus Dr. M.A. Methu Sedupati and others, pronounced on 20th April 2022. In this judgment, the Supreme Court has held that merely because doctors could not save the patient, he or she cannot be held liable for medical negligence. The facts of the case would be that the sad demise of husband of appellant number 1 after his long illness resulted in initiation of legal proceedings on a bona fide belief that the cause of death of her late husband was post-operative medical negligence and follow-up care. The National Consumer Disputes Redressal Commission held that it was not a case of post-operative medical negligence as being alleged by the appellants, and dismissed the complaint by the impugned judgment, which is the subject matter of appeal, filed at the instance of appellants under Section 23 of the Consumer Protection Act 1986. The Supreme Court has held that a medical practitioner is not to be held liable simply because things went wrong from mischance or misadventure or through an error of judgment in choosing one reasonable course of treatment in preference to another. In the practice of medicine, there could be varying approaches of treatment. There could be a genuine difference of opinion. However, while adopting a course of treatment, the duty cast upon the medical practitioner is that he must ensure that the medical protocol being followed by him is to the best of his skill and with competence at his command. At the given time, medical practitioner would be liable only where his conduct fell below that of the standards of a reasonably competent practitioner in his field. The term negligence has no defined boundaries, and if any medical negligence is there, whether it is pre or post operative medical care or in the follow up care, it is always open to be considered by courts or commission, taking note of the exposition of law laid down by this court, of which a detailed reference has been made, and each case has to be examined on its own merits in accordance with law. Facts on record would show that the treating doctors are academically sound and experts in the field of kidney transplantation. It is also not the case of the appellants that the patient was not medically treated by the well qualified doctors at the time when kidney transplant surgery was undertaken by the team of doctors. The doctors are expected to take reasonable care, but no professional can assure that the patient will come back home after overcoming the crisis. At the same time, no evidence came on record at the behest of the appellants which could demonstrate that it was a case of post operative medical negligence or follow up care on the part of treating doctors, and both the doctors who recorded their statements on behalf of the appellants are not expert doctors in the field of kidney transplantation. Merely because they are doctors by profession would not be considered to be an opinion of experts. On the contrary, the two experts who deposed on behalf of the respondents are admittedly experts of the field. Thus, the Commission did not commit any error in arriving to a conclusion that in post operative medical negligence or follow up care there was no negligence being committed by the respondents. In consequence thereof, the impugned judgment does not call for interference.